Welcome to ATSWA Academy, and this is the third part and a very lengthy part, but I'll try and make sure I I I don't really dwell much on the on the topic, okay, or the section or subsections. I don't really dwell much on them, and you can just you have the material. If you want the material, you can you know ask via the comment section so that I can share the link or tell you how to get it. Okay, so the third part is we want to look at the sources of Nigerian law. Okay, we've looked at the senses of it. Okay, we've looked at the sense when you hear source of law. There are three senses. There are more, but we limited ourselves to three senses according to the PDF. So, but this is now looking at the whole thing in general, the sources of law in general. Now, there are five of them, and number one, we have the Nigerian Constitution. Number two, we have Nigerian legislation. Number three, we have the received English law. Number four, we have customary law, and lastly, we have judicial precedents. Those are the sources of Nigerian law. Okay, this received English law consists of the common law, the doctrine of equity, statute of general application in force in England on January 1, 1900, and English law made before October 1st, 1960, and extending into Nigeria. We are still coming to that. We explain them one after the other. All right. So let's start with the first one, which is the Constitution. Let's start with Constitution. So the Constitution is a document containing the rules and regulations, including the norms and ethics concerning the ways and manner in which a country is to be governed. Is a document, that's number one, containing rules and regulation. Number two, including the norms and ethics concerning the ways and manner, that's number three, in which a country is to be governed. This number four, document, rules and regulations, ways and manner a country is to be governed. Okay, according to Wade and Brainley, these guys, a constitution is a document having a special legal sanctity which set out the framework and the principal functions of the organs of government of state, and declares the principles governing the operations of these organs. Okay, that's their definition. Now we want to look at the features or characteristics of the Federal Republic of Nigeria 1999 Constitution. Okay, now we have number one, we have supremacy of the Constitution. That's number one, and this supremacy of Constitution is stating that the provisions of the Constitution are binding on all authorities and persons throughout Nigeria. Okay, it's supreme. It is supreme. Nobody, no institution, no arms of government, no single soul is above the Constitution. So the Constitution is like the law of the land. Okay, it is the provisions of the Constitution are binding on all authorities and persons throughout Nigeria. Binding on all authorities and persons throughout Nigeria. Being the basic law of the land, its provisions are supreme over all other laws, and any law inconsistent with its provisions shall be null and void. So any law that you make that is not in accordance with the Constitution will be declared null and void. Okay, so in addition, no part of the country shall be governed except in accordance with the constitution, and that's why constitution is what is supreme. Okay, is supreme. The second one is the written form. That is to say that the Constitution of the Federal Republic of Nigeria is a written constitution, that is a written document. It is written not merely in the sense that it is a document, but essentially because it is one in which fundamental principles concerning the organization of government, the powers of its various agencies, and the rights of the subject are written in one document. It is not just because it's a document like literary source. Okay, that's in part two. It's not literary source because it's not as if it's constitution itself, it's law itself. Okay, it's law. This material that we are using is just a document that contains law that explain. Let me use the word explain. Okay, or try to teach it. Okay, try to teach it, but itself is not the law. All right, because if you are looking for validity of something, you go to the constitution. You don't come to business law PDF. No, no, you don't come here. You understand my point? This just explain, and that's why constitution is what is not just a mere document. Okay, it's a written constitution. All right. The third one is rigidity. 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 So rigidity is talking about rigidity. Constitution cannot be changed or amended easily because it requires special process, which is not only difficult but is also complicated, and the special process is actually laid down in the constitution themselves. So it is rigid because of it is a rigid constitution because it is not easy to be amended or changed. That's why it is called rigid. It is not easy to be amended or changed. That's why it is referred to as what? As rigid. So let's proceed to the third one. But there's a point here that you guys need to note. You need to know, it should be noted that a rigid constitution is necessarily written, but we should also know that not all written constitutions are rigid. A rigid constitution is necessarily written. That is to say, every written constitution, every rigid constitution must be a written constitution. Okay? Must be a written, every rigid constitution must be a written constitution. But not every written constitution is a rigid constitution. That's what this phrase is trying to tell us. But we should also know that not all written constitutions are what? Are rigid. That is, constitution may be written and still remain flexible. Flexible. Okay? So, the fourth one is the federal system. The constitution creates a federal system of government. This is true not only in Nigeria but Ghana. In a federal system of governance, the powers of governance have been distributed between one level of government and another. Each state is autonomous to the extent of the powers and duties conferred on it by what? By the constitution. Under the 1999 federal constitution, Nigeria remains a federation consisting of 36 states and the Federal Capital Territory. See section 2 and 3 of the CFRN, Constitution of the Federal Republic of Nigeria, 1999. Okay. The federal structure recognizes 3 tiers of government, namely the federal, the state, and the local government. We run a federal system of government because the Constitution creates it. Okay, because the Constitution creates it. In addition to the federal system, Ghana has a unitary system. In addition to the federal system, Ghana has a unitary system. unitarism is the national or the central government that is supreme over other levels, that is other tiers of government that might exist in the state. And in this context, other levels of government refer to the local authorities. In short, the powers of the local authorities have not been derived from the constitution but as a result of the wishes of the national government. All right. So now the fifth one is separation of power. Separation of power. Now we said there is the fourth one says federal system. That is, we have the state, we have the federal, we have the state, and we have the local. But this is now saying that there is what we call separation of powers. What is separation of powers? The Constitution separates the powers of government into executive, legislative, and the judiciary branches. So separation of powers implies that the various organs of government should function separately and independently of one another. That way, they constitute check and balances. Separation of powers, the executive, legislative, and what? And judicial branches. Okay? So, that is for that. Now, number 6 is fundamental human rights. These are basic rights to which every citizen is entitled within the polity as entrenched in the what? In the Constitution of the Federal Republic of Nigeria, 1999. So these are rights that every citizens are entitled, to benefit. The Constitution says that every citizen of the particular country that the Constitution is controlling, the citizens have what we call fundamental rights. So these are the rights that they must enjoy. Okay, the right that they must enjoy. Rights are the right to life, right to dignity of human person, right to personal liberty, right to fair hearing, right to private and family life, right to freedom of thought, conscience, and religion, right to freedom of expression and the press, right to peaceful assembly and association, right to freedom of movement, right to freedom from discrimination, right to acquire immovable property anywhere in Nigeria, a right to compensation upon compulsory acquisition. These are rights, okay? These are rights. And if you check the Constitution, you would see more of them and their meaning. So the Constitution, the features and characteristics of Constitution are 6. So we have the first one is supremacy. The first one is supremacy of Constitution. The second one is written form. The third one is rigidity. The fourth one is federal system. The fifth one is separation of powers. And the sixth one is what? Fundamental human rights. So that is for what? For Constitution. So out of the 5 sources now, we've been able to understand one of it. Now let's go on to the second one, which is the common law. The common law. Please pay attention. What is the meaning of common law? Meaning of common law. The term common law is as a part of the received English law. So common law is part of the received English law because we said the second one is the received English law, in which consists of the common law, law of equity, and we have what? Doctrine of what? Statute of general application, doctrine of equity. I said law of equity. Doctrine of equity, statute of general application. Okay. Then we have so this is one of the received English law. Okay. And as a part of the received English law in Nigeria, it means the law developed by the Old Common Law Court of England. So the law is actually developed by the Old Common Law Court of England, namely the King's Bench, the Court of Common Pleas, and the Court of Exchequer. There were originally several systems of local customs in England, but under the guise of enforcing the customs of the realm, the common law judges developed a system of law known as the Common Law of England. No, these common laws are rules of the common. Okay, rules of the common law are therefore found in judicial decisions. So, the common law is still kind of judicial precedents. Okay, they are like the judgment made and that is passed. Okay, so that cases like that they just judge it the way it has been judged by higher courts. Okay, so but these were they were done in England. They are old common law courts of England. Okay, they are developed by the common law courts, the old common law courts of of England. So this is known as the common law of England. Rules of common law are therefore found in judicial decisions. The rules cover criminal law and civil law. You understand them later, but with the exception of the law on contempt of court, that the common law of crime is not part of Nigerian law. Okay, so the common law of crime, that is the criminal law, is not part of Nigerian law. Okay, it's not part of our own Nigerian law. So that's common law, but we'll still see so in understanding this better, all you need to know about the common law is that one, they are received, they are, it's part of the received English law. Okay, but these laws are developed by the old common law courts of England. And when you say the old common law courts of England, there are three of them. We have this one, we have this one, and we have this one. Okay, those are the three combined together called the old common law courts of England. So it is the law that they developed, their judgment, okay, their judgment that is now being passed to other lower courts. Okay, their judgment that is now being passed to other lower court, that is their judgment in a particular case. When lower courts are are faced with such kind of case, they just use that decision made by the old common law courts of England. They just use their judgments to judge the same case. So that is and this their law, that's number two. This their law comprises of criminal law and civil law. Criminal law and civil law comprises of criminal law and civil law. But the civil law, the criminal part of it is not part of the Nigerian law. Is not part of what of the Nigerian law. So those are the three things that you need to know about the common law. Now let's move on to doctrine of equity, which is the second one. Now the doctrine of equity, equity is the law developed by the Old English Court of Chancery as a result of the rigidity of the common law. Okay, so doctrines of equity is like a remedy to common law. So because of the rigidity of the common law, there was a need to develop what we call equity by the Old English Courts of Chancery. Okay, whenever the rules of common law worked hardship or injustice, the litigant sent a petition to the sovereign as the fountain of justice and the royal council. The Lord Chancellor granted relief on behalf of the sovereign and the council as the thought fit. He followed no established principles in dealing with such matters. Accordingly, whenever there was a conflict between a rule of equity and a rule of common law on the same matter, the rule of equity was to prevail. Finally, it should be mentioned that because equity was developed by a court, its rules are found only in judicial decisions, except that there are many equitable rules that have been incorporated into statutes. Okay, they have been incorporated into statutes. Now, the most important thing that you should know are what we call the maxims of equity. They are like principles. Okay, they are like the general principles. They are like the general principles which are governed by the way in which equity operates. Okay, in which equity operates. So I think there are like 12 of them. So we have equity will not suffer a wrong without a remedy. Equity follows the law. Where there is equal equity, the law shall prevail. Where the equities are equal, the first in time shall prevail. He who seeks equity must do equity. He who comes to equity must come with clean hands. Delay defeats what? Delay defeats equity. This is still referring to um he who comes, no, no, where the equities are equal, the first in time shall what? Shall prevail. Delay defeats what? Equity. So we have more of them. Equality is equity. Equity looks to the intent rather than the form. Substance over form. uh it's an accounting concept, and it's part of accounting concept and convention. So equity looks on that as done which ought to be done. Looks on that as done which ought to be done. Equity inputs an intention to fulfill an obligation, and equity acts in personam. Okay, equity acts in personam. These are maxims of equity. Okay, you can be asked to name five, you can be asked to name 3, 4, 5, 7, so you need to at least know five of them. So let's move on to the fourth one, which is um the statute of general application. Statute of general application. We said the received English law, we have the common law, we have doctrines of equity, we have statute of general application. So now we are at the third one, which is the statute of what? Of general application. So statute of general application that were in force in England on the first day of January 1900 form the third group of received English law in Nigeria. The courts are entrusted with the responsibility of ascertaining and applying those statutes that meet the laid down criteria for application under the general what? Provision. So statutes of general application do not apply in states of the Federation of Nigeria. It's not as if it applies to all the states, okay? And that have their local laws. Okay, states that have their local laws or statutes, the statute of general application doesn't apply. Okay, as a matter of fact, they have never applied in states of the defunct western region. So when where a state have their local laws or statutes, the statute of general application is not found or used in those states. So let's move on to the third one. Okay, the third one under the sources of what? Under the sources of law. We've looked at the first one, which is constitution. We've looked at the second one, which is received English law. The third one is what? Judicial precedents. Judicial precedents. So what is judicial precedent? And I think you should have been hearing court judge court cases, the judgment from higher courts that is being passed to the lower courts, like that of the common law. So judicial precedents, or they can sometimes be called case law, consist of laws found in judicial decisions. A judicial precedent is the principle of law on which a judicial decision is based. It is the ratio descending, literally the reason for the decision. Ratio descending means the reason for the decision. Okay, the reason for the decision. It follows that it is not everything said by a judge in the course of his judgment that constitutes a precedent. Only the pronouncement on law in relation to the material fact before the judgment constitutes a precedent. Any other pronouncement or law made in the course of a judgment is an obiter dictum, that is, a statement by the way, and it does not form part of the ratio descending, which is the reason for the decision. So let us quickly break this thing, because the judicial precedents, now we know number one is what? Is a case law. That is to say, it's a judicial decision. Okay, but there are two things now that is being mentioned. Number one, they said there is what we call ratio descendi, and there's another one we call obiter dictum. Now, to differentiate the two, a statement was made mentioned. It says that it follows that it is not everything said by a judge in the course of his judgment that constitutes a precedent. So let's say there is a case in front of a judge, or let's say you have siblings that are fighting over who to wash the plate, or who to cook. Let us use it now. Let us use who to cook. Okay. And you now said that before you, as the elder sister, now said, okay, let me decide this case now. And you now said, mommy said that the eldest should always be the one to wash the dishes. That is your judgment. Okay. Like that now, what you said now, that judgment is because you you the decision is based on a principle of law, what the validity has given to you. It has become a judicial decision, which is what judicial precedent, and that is what we call ratio descendi. The reason for the decision, that's ratio descendi. Now if you now further said, but always you should know that this girl is younger now, she's your younger sister, she can't even hold the plate, she can't even wash the plate clean, she's too young to even do what you're asking her to do. All of those statements that you made after the decision is what we call obiter dictum, because they are not the reason why you made the judgment. Okay, they are just by the way, statement by the way. And I hope you understand judicial precedent and what I just explained. Now let's move on to the next one, which is the fourth one, which is legislation. Legislation comprises laws. Legislation comprises laws. It comprises laws passed by parliament or the legislative branch of government, and that is the state house for state government of assembly, that is state house of assembly, that's for states, and the national assembly for federal. So when it is national assembly, they are called acts at the federal level and laws at the state level. Okay, they are called acts at the federal level and laws at the state level. So legislation may also be exemplified by the constitution and subsidiary legislation. Since the coming into force of the 1992 constitution in Ghana, many acts of parliament have been passed. These are the enactments made by or under the authority of the parliament, established by the constitution. And that's why I said, I think when we were explaining in part 1, or it is in part 2, when we're explaining the legal and the formal, I told you that we have the constitution. Constitution is supreme. Okay, that's validity. That's where validity comes from. But authority comes from what? From the parliament. Okay, from the parliament. I don't know if you understand what I'm trying to say. The act, it gets its validity from the constitution, but to become part of the body of rule of law, it has to pass through the authority of what? Of the parliament, which is even which that their own authority is valid as well, by what? From is valid even in the constitution. I don't know if you understand what I'm trying to say. So that is that. So the situation in Ghana is almost the same with that of Nigeria. However, why both countries have federal constitutions, Ghana has a unitary constitution. Ghana has what we call a unitary constitution. Now we are moving on to the customary law, which is the fifth one. The customary law. I think there's a sixth one, which is called the international law. The international law. Okay, the international law. But we have what we call the customary law. And yes, you guessed right, it's from customs. Okay, customary law means the rules of law which by custom are applicable to particular communities in Ghana and Nigeria. Okay, they are therefore the customs accepted by members of a particular community as a binding upon them. They are customs. Okay, there are customs that is, that is accepted by members of a particular community, okay, as binding upon them. They are customs. It's just customs, okay. They accept it. It's just customs, okay, that is being accepted. So that's what we call customary. There are rules of law which by custom are applicable to a particular community, okay, in Nigeria and Ghana, So in Nigeria, customary law consists of two classes, namely we have two classes. We have the ethnic customary law, the ethnic customary law, and the Islamic customary law, which we call the Sharia law. Okay. So this ethnic customary law, we are referring to laws in your particular community, laws in, we have there are tribes that believe, okay, this is how we do our things. There are another tribes that believe this is how we do our things, and they accept, the members of those tribes accept that culture, accept that custom, okay. They accept that custom, okay. They accept that law, that okay, if this is how we do it, you can't do it outside this, okay. So we have the Islamic customary law, we have the ethnic customary law. So ethnic customary law in Nigeria are indigenous. Each system of such customary law applies to members of a particular ethnic group, and I think you understand. So Muslim law is religious law based on the Muslim faith, okay, based on the Muslim faith, and applicable to members of the faith no matter where they are, okay, no matter where they are, it is applicable to the members of the faith. In Nigeria, it is not indigenous law, it is received customary law introduced into the country as part of Islam, okay, as part of what? Islam. Is not indigenous law, and that's why we had to classify them. We have ethnic customary law and we have the Islamic customary law. So it's a received customary law introduced into the country as part of what? As part of Islam. So ethnic customary law is unwritten. There are several systems of customary law in the country, each ethnic group having its own separate system. Unlike ethnic customary law, Islamic customary law is principally in written form, okay. So there are so many discussions under this, but let's move on to characteristics of customary law, okay, because this is where it is very important. Number one, it is largely unwritten. Members of the community or group to which it relates generally consider it as binding. As such, it is often described as a mirror of accepted usage, okay. As binding, they believe they generally consider it as binding. They generally consider it as binding. You say, you will hear something like, that is how our forefathers have been doing, and we just have to continue like that. It is generally considered, the community, the members generally consider it as binding, okay. Now, the third one is that it is established by proof through assessors or authoritative books if it has not been so used by the court to be judicially noticed, okay. So as in the case of all customary law, it has to be proved in the first instance by calling witnesses acquainted with the native customs until the particular customs have, by frequent proof in the court, become so notorious that the court take judicial notice of them. And the third one is that it is largely flexible. It is largely flexible. Now, establishing customary law. Not all customs are part of customary law, okay. That is part of the source of Nigerian law. Not all customs are part of it. So it is those that are pass through this criteria, okay, that is recognized, okay. So before a custom becomes law and it is recognized by courts, the custom must pass the following validity test. It's called custom validity test, validity test. The first one is the repugnant test. And this repugnant, it must not be repugnant to natural justice, equity, and good conscience. Okay, repugnancy test. It must not be repugnant to natural justice. That is, must not go against natural justice or equity, that is fairness and good conscience. It must not. Okay, you can't say it's our custom that we kill one of the twins, okay, or any twin child, they must be killed because they are cause. It is against natural justice, so it cannot be considered part of the customary law. Do you understand? So that's the repugnancy test. It must not be repugnant to natural justice, number one, equity, number two, and good conscience, number three. So the second one is that it must not be incompatible with an existing law. It must not be incompatible with an existing law. It must not be against an existing law, especially or the supreme law, which is the constitution. Okay. And lastly, it must not be contrary to public policy. It must not be contrary to what? To public policy. Now, the last one is treaties. So, what is treaty? This is the international law that I made mention of. So, a treaty is a formally concluded and ratified agreement between sovereign states. A formally concluded and ratified agreement between sovereign states. It is an agreement under international law entered into by actors in international law, actors, namely sovereign states and international organizations. A treaty may also be known as an international agreement, protocol, covenant, convention, pact, or exchange of letters, among other terms. So, but there's something important. Okay, bringing this to example, let me give you an example. Let's say um there is there's an agreement, okay, that there's an agreement between US and Nigeria that every of their citizens can use, because they are used to driving cars on the right side or the left side, you know, it, and there's an agreement between Nigeria and US that every of their citizens can drive that kind of car. Are you getting my point? There's an agreement. They both signed the agreement that, okay, so far you are a citizen, you are a US citizen, then you can drive car that is not used, that is not permitted in Nigeria. Okay, if there is an agreement like that, it's just, this is an example. Okay, now, before any US citizen can actually enjoy that that law, it must be what? Accepted and go through the legal source of law, which is what? The parliament. The parliament will now have to put it as an act so that it can what? Be valid via the constitution before a US citizen can actually, enjoy the law. I don't know if you understand my point. So there's what we call treaty, the agreement, but that is not all that makes it what? A law. It must be, be imputed via the parliament, via legislation. Okay, and that is the end of chapter 1. Thank you for watching. I hope you have understanding of it. So this is a very detailed explanation, but if you want further discussion or you have some questions, the comment section is there for you. Or if you want to join the WhatsApp group where we have discussions and do one-on-one follow-up, you can check the link on the group. There's a link that you can check and just join the group. See you in the next video.